Preliminary hearing discovery. To what is a defendant entitled? I'm Fellows Attorney James Wirth, and that's the question that we have related to preliminary hearings and felony prosecutions in the state of Oklahoma, and what discovery is available to the defendant ahead of time. So, generally speaking, the state of Oklahoma, if we're talking about a criminal matter, the discovery statute's pretty clear. All discovery disputes must be resolved at least 10 days prior to trial. So there's no ambush and no surprise when it goes to trial. But we're talking about an earlier proceeding, not a trial, the preliminary hearing. And that is the first major hurdle for a prosecution, where the prosecutor has to show that there's probable cause a crime was committed and the defendant committed it. So what is the state required to disclose ahead of the preliminary hearing? Well, that is noted by statute. It's Title 22, Section 258, and actually says that the state is not required to provide anything to the defendant. However, there are reasons why the state may want to do so. So what it says is that the district attorney shall determine whether or not to make law enforcement reports available prior to the preliminary hearing. If they do not make them available, though, the preliminary hearing cutoff is not applicable. So what is the preliminary hearing cutoff? That is also in Section 258, subsection 6. And it says, once a showing of probable cause is made, the magistrate shall terminate the preliminary hearing and enter a bind-over order. But it says, however, that the preliminary hearing shall be terminated only if the state made available for inspection law enforcement reports within the prosecuting attorney's knowledge or possession at the time to the defendant 5 working days prior to the preliminary hearing. So if the district attorney, the prosecutor, provides the discovery of all the police reports that they have knowledge of and possession of at least 5 days prior to the preliminary hearing, then the court can terminate the preliminary hearing once the court finds that the state has introduced enough evidence to establish probable cause a crime was committed and that the defendant committed it. If the state does not provide those materials at least 5 days ahead of the preliminary hearing, that means the defendant has an opportunity to continue asking questions. The magistrate or the judge cannot cut off the preliminary hearing early, and essentially becomes a discovery hearing for the defendant. So if the question is how much discovery is the defendant entitled to under Oklahoma law before the preliminary hearing, the answer is none. However, in practice, it is common for the state to provide some discovery so that they can try to cut off that preliminary hearing as soon as probable cause is established in order to deprive the defendant of using a preliminary hearing as a discovery hearing. So if you're dealing with a criminal case in the state of Oklahoma, have questions about preliminary hearing or other procedural issues, you're going to want to talk to an attorney about that privately and confidentially. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.